Dear colleagues, dear guests, my name is Anna Gilsbach. I'm a lawyer from Berlin and a member of the German Bar Association Human Rights Committee. I'm very pleased that today, January 24th, on the Day of the Endangered Lawyer, we are able to continue a long-standing tradition of events. This year, I have the pleasure to welcome you on behalf of the DAV, the German Bar Association, to a series of video messages from our colleagues from Poland and Belarus, countries where lawyers, and especially human rights defenders, are persecuted by state authorities simply for performing their work. I would also like to take this opportunity to remind you of the history of the Day of the Endangered Lawyer. On 24 January 1977, 4 Spanish trade union lawyers and a clerk were murdered in their Madrid office by neo-fascists. In 2009, the Day of the Endangered Lawyer was created to commemorate this painful event by the European Democratic Lawyers, a federation of lawyers' organizations. Today, various associations such as the CCBE and the ELDH, the European Association for Democracy and Human Rights, support this project. The tasks of the DAV as an organization representing the interests of the entire legal profession are manifold. The functioning of the rule of law is a fundamental prerequisite for us lawyers to be able to fulfill our tasks. By virtue of our statute, we have hence made it our duty to warn against threats to fundamental and human rights. Especially in the age of globalization and a constantly growing international network of the legal profession, we must all the more stand by colleagues abroad who are at risk when their work is made difficult or even impossible by state pressure and repression. It is precisely these colleagues we are thinking of today. The Polish constitutional crisis began in 2015 with disputes over the election of judges to the Polish Constitutional Tribunal. After the Peace Party won a majority in October 2015, it first enacted extensive reforms about the Polish Constitutional Tribunal, which disempowered the tribunal and led to it being staffed almost exclusively with peace-affiliated judges. Subsequently, extensive reforms took place in 2017 and 2018 with regard to the other Polish courts. A key component of these reforms are regulations related to retirement and the appointment and removal of judges. In order to get an objective first-hand assessment of the situation, we asked representatives of the legal profession, the judiciary, and the academia to give their views on the situation. From Poland, today we welcome Mikołaj Pietrzak, Natalia Klima-Piotrowska, Marcin Gorski, Dariusz Mazur, and Krzysztof Sokołowski. The situation in Belarus is even more complicated. Lawyers representing political activists or representatives of the political opposition and protesting citizens are not only hindered in their work, but also arbitrarily detained, criminally and administratively persecuted, and even disbarred, a violation of international standards. We thank the UN Special Rapporteur on the situation of human rights in Belarus, as well as lawyers directly affected by the repression, including the winners of the CCBE Human Rights Awards, for their report on the situation. From Belarus today, we welcome Anais Marin, Dimitrilajevsky, Natalia Matzkiewicz, Ludmila Ulyashina, Mikhail Kiryuk, and Ludmila Kazak. We are looking forward to hear your statements, and thank you.
As we celebrate the Day of the Endangered Lawyer, it's good to remember that wherever lawyers are in danger, in fact, civil rights, human rights, and fundamental freedoms, the legal security of entire societies is in danger. There can be no effective protection of rights and freedoms where lawyers do not have the freedom to practice their profession safely without fears of reprisals, repressions, or obstructions. There can be no effective protection of rights and freedoms where there is no strong and independent bar association, independent in particular from the executive branch of power. There can be no effective protection of rights and freedoms where there is no autonomous disciplinary system, so that lawyers are not punished for merely protecting the rights and freedoms of their clients. There can be no effective protection of rights and freedoms where lawyers' confidentiality, client-lawyer privilege, is not protected by law. We see this on the example of Belarus, so close to Poland, where brave lawyers such as Ilya Salej, Maxim Znak, Lyudmila Kazan have been repressed merely for bravely performing their duties as advocates in protection of the rights and freedoms of their clients, members of the democratic opposition. They have, in fact, faced imprisonment and other forms of reprisals by the Belarusian state for their role as advocates. I would like to salute these brave lawyers today. Unfortunately, these attacks on lawyers take place throughout the world, most notably recently in Afghanistan, and lawyers continue for many years to be repressed in Turkey and other states throughout the world. However, this should not lull us into a false sense of security in the European Union, where we also see these telltale signs of the undermining of the system of legal security by attacks on lawyers. These attacks, perhaps not so spectacular and not so destructive as those with which our colleagues in Belarus are met, but demonstrate a will to subjugate lawyers to the executive power, to political power, and thereby weaken the system of protection of rights and freedoms. Perhaps most notably in Poland, we've seen the establishment of the disciplinary chamber of the Supreme Court, which through cassatory proceedings is intended to subjugate our otherwise autonomous disciplinary proceedings. We have seen increased surveillance against lawyers with hundreds of attempts over the past 4 years to violate client-lawyer privilege in the Warsaw Bar Association alone. We have seen the Pegasus invigilation system, surveillance system used by the government to control the correspondence of prominent lawyers defending members of the political opposition. These are telltale signs of the undermining of the very delicate system of protection of rights and freedoms, which is a necessary component of any democratic state. And these require a strong reaction on the part of not only all lawyers across the world, but all democratic and civil societies across the world. We urge you to protect your lawyers so that they can protect you. I would in particular like today to express my solidarity with our brave colleagues in Belarus who have paid such a high price for their role in protecting rights and freedoms. Thank you.
Hello, my name is Natalia Matzkiewicz. I'm an advocate in Poland. I'm a chairwoman of Human Rights Committee at the National Bar Council and the member of District Bar Council in Katowice. Thank you very much for the opportunity to say a few words about the situation of professional lawyers in Poland in connection with the actions of the Polish authorities resulting in the violation of the rule of law, concerning especially the independence of the courts. National Bar Council and many district bar councils in Poland, as well as the vast majority of advocates, are opposed to the attack on the independence of the judiciary, which is a guarantee of the proper administration of justice, and fundamental to the effective representation of our clients' interests. The bar has repeatedly expressed a critical position towards the functioning of National Council of the Judiciary, recognizing that in its present composition and formula, it is not an impartial body independent of the legislative and executive powers, as well as towards the disciplinary chamber, stressing that it is not a court within the meaning of Polish constitution and European standards. Although, as is well known, the judges and prosecutors are currently the group most exposed to reprisals for involvement in the defense of the rule of law in Poland, in particular for the execution of European Court of Human Rights and European Court of Justice judgments, we are aware that we, as a professional group, we may be next. Today, we do not have too many proceedings against advocates in connection with their activity in this area. However, we are aware that this may change for several reasons. Firstly, the mentioned before critical attitude of the bar authorities towards the violation of rule of law and the support of judges in their activities to defend it. Secondly, personal involvement of many advocates in pro bono representation of judges and prosecutors protecting the rule of law in numerous proceedings, disciplinary, criminal, civil, and before the European Court of Human Rights and the European Court of Justice. Thirdly, repression against advocates may also result from the submission of the applications for the exclusion of judges appointed with the participation of the National Council of the Judiciary in the composition formed in 2018 from examining cases. Such actions taken by advocates may ultimately result in disciplinary proceedings, which unfortunately has already happened in several cases. It should be borne in mind that the cassation in disciplinary cases against advocates is recognized by the disciplinary chamber. This is a mentioned before body operating in the Supreme Court building, whose status since its inception has been questioned by the legal community in Poland and abroad. And finally, both European Court of Human Rights and European Court of Justice decided that the disciplinary chamber is not a court within the meaning of Polish regulations and European standards. The authorities of the bar have consistently refused to recognize the disciplinary chamber as a court. It refers to the Supreme Disciplinary Court and the bar disciplinary attorney, as well as to the National Bar Council. As a result, cases in which the disciplinary chamber examined a cassation and issued rulings are treated by the bar as unrecognized. This is a very undesirable situation, as it creates a state of legal uncertainty and increases the risk of the limitation period expiring. What is also important, the disciplinary chamber once made a ruling recognizing that the public prosecutor general, who is also the Minister of Justice in Poland, may appeal against each judgment of the disciplinary court of advocates, also of first instance. It gave the public prosecutor general a tool to revoke every ruling of the disciplinary court, including the decision to discontinue the proceedings. This resolution of disciplinary chamber, as well as its status, has been subject of the request for preliminary ruling submitted to European Court of Justice by the Disciplinary Court of Bar Association in Warsaw, and the case is still pending. I would also like to stress one very important issue which has been revealed recently and which is quite disturbing as regards the advocate secrecy being the fundament of our job. I mean the surveillance of one of well-known Polish advocates, and this situation actually shows where we are. Summing up, although we are currently not dealing with many repressions against advocates involved in the defense of the rule of law, the authorities, Polish authorities, have tools to repress advocates, to repress us for this activity, and they can use them at any time, which may actually have a chilling effect, and hopefully it will not. Thank you very much.
Good evening, ladies and gentlemen. My name is Marcin Gorski. I'm an attorney at law and a professor of the Faculty of Law of the University of Łódź. I'm also a member of the Center for Research on Migration Law of the Polish Academy of Science and the head of the legal department of the local government of the city of Łódź, which is still controlled by the democratic political forces. For 7 years, I was a member of the Human Rights Committee of the Polish Bar of Attorneys at Law. In my academic and legal practice, I focus on European Union law, on international law, constitutional law, and human rights. I have many friends in Germany, including from the universities of Cologne, Constance, and Hildesheim. Ladies and gentlemen, Polish history after 1989 is a story of incredible success on many levels. This is the story of the state that within one generation's lifetime built the foundations of functioning democracy, made a huge leap in economic terms, anchored itself in Euro-Atlantic structures, and successfully joined the process of building the European community of values of human rights and prosperity. This story is also one of the threads of the European success story. After all, Łódź, from which I'm talking to you now, is located just 422 kilometers away from Berlin, which is 80 kilometers closer than Munich. And it is 100 kilometers closer to Brussels than Rome. Therefore, the situation that we have been observing in Poland since fall 2015 makes us so particularly sad and disappointed. The ruling party, using populist slogans, frauds in elections, and empty promises, made an unprecedented attack on Polish democracy. The Constitutional Court was turned into a machine commissioned by the government. The prosecutor's office and the secret services were subordinated to political powers, and the courts are gradually pacified. Political repressions also impact advocates and attorneys. Reports only from the recent weeks cover secret surveillance of a lawyer representing opposition leaders in the time immediately preceding the elections with the use of the Pegasus system. Criminal charges against a professor of law and the head of the Organization of Judges for pointing out in the press interview that Polish courts must comply with the rulings of the European Court of Justice. Demand by the disciplinary officer of common court subordinate to political authority to prosecute an attorney at law for challenging in the course of the court trial the status of persons appointed to the Supreme Court in breach of the Polish Constitution and Article 6 of the European Convention. We have a situation of a lawyer representing a judge unlawfully suspended by an illegal so-called disciplinary chamber of the Supreme Court, who was immediately faced with the demand to institute disciplinary proceedings against him for his criticism against the government. We have many slap-type lawsuits and disciplinary complaints which are brought against academics to force them to stop criticizing the government. These repressions are combined with incessant campaign of the ruling politicians and legal practitioners. They are constantly vilified and attacked using the media apparatus that obeys their political orders. Recent events also give us strong grounds to believe that many lawyers are most likely being tracked by the Secret Service with the use of the Pegasus system. This may especially be true of those lawyers who represent people or institutions from circles reluctantly perceived by the ruling party, including myself. Your interest, ladies and gentlemen, in the current political and legal developments in my country and your support for democratic forces in Poland is highly appreciated. Thank you very much.
Dear listeners, my name is Dariusz Mazur. I'm a judge of Regional Court in Kraków with 25 years long judicial service I'm also the spokesperson of the second largest association of judges in Poland called TIMIS. Currently are faced 4 disciplinary proceedings, all for speaking out in public about the dangers for the independence of Polish judiciary. In my background, you can see the poster with 3 judges who are suspended for the same activity. Now I'm going to deliver my short description of the situation of Polish judiciary. The independence of the Polish judiciary has been systematically dismantled over the last 6 years. A pseudo-reform of the judiciary has been carried out in which the National Council of the Judiciary, responsible for appointment of judges, have been politicized in violation of the Polish constitution. Between 2019 and 2021, both the European Court of Justice and the European Court of Human Rights have issued a number of rulings showing that the new Judicial Council is not independent of the political factor, which also means that the so-called neo-judges appointed with its participation are not independent. Many Polish judges have taken up the fight to preserve the independence of the judiciary by criticizing the pseudo-reform in the media, submitting requests for preliminary rulings to the European Court of Justice, and questioning the legal status of neo-judges. In response, the Polish government launched a real witch hunt against judges who defend the rule of law, in which the role of Holy Inquisition is played by the disciplinary chamber of the Supreme Court, the Minister of Justice, and court presidents, which have groundlessly suspended 10 judges. The role of the inquisitors is played by 3 central disciplinary commissioners and prosecutors from the dedicated unit of the State Prosecution Service, all of whom are appointed and subordinated to the Minister of Justice. The role of Hammer of Witches is played by the infamous Mazur Act, which prohibits judges from applying EU law under the threat of professional death, which means removal from the judicial profession. This system enables politically motivated persecution of judges in the following 4 ways. Firstly, disciplinary proceedings currently applied against over 100 judges. Secondly, criminal proceedings currently against at least 8 judges. Thirdly, administrative repressions like temporary suspension of judges. Fourthly, a brutal anti-judge campaign conducted by the state media. All the repressive tools described above are used to suppress judicial independence in Poland. Assuming that independent judiciary is the basic element of democracy, Polish democracy is seriously endangered and requires protection. Otherwise, there will soon be a country in the very heart of Europe deprived of independent judiciary. This is a threat to the legal integrity of the entire European Union, as the disease of autocracy is extremely contagious. Thank you very much.
My name is Krzysztof Sokołowski. I am a lawyer. I am a member of the District Bar Council in Lublin, as well as a member of the Human Rights Committee of the Supreme Bar Council. I'm also a member of the board of directors of the Professor Zbigniew Hołda Association. The association is also a founding member of the Committee of Defense of Justice, which provides support to lawyers suffering repression and provides the rule of law support fund. My professional practice, on the other hand, focuses on providing legal services in business area. Presently, there is a really big issue with appointments of judges in Poland. According to the resolution of Polish Supreme Court and jurisprudence of European courts, the present procedure of appointing judges does not guarantee that a case will be heard by an independent and fair court. Once I had a court hearing. The judge who was running it was appointed under the flawed procedure. The judge was also a vice president of the court appointed by the Minister of Justice. At the hearing with the judge, I reported procedural defects. I pointed out that the court composition didn't guarantee independence. This is the procedure provided by the law. A lawyer is obliged to report procedural error in the course of proceedings. After my motion, the hearing was adjourned. After some time, I was informed that some disciplinary proceedings were started against me. The order to start such proceeding was issued by the Deputy Minister of Justice. The order was based on a letter sent by the judge to the Minister of Justice, in which he described the course of the court hearing and declared that he would continue with the case despite the fact that he had been appointed under the flawed procedure. The letter was not disclosed in the case file, and no parties were informed of that. I only learned about that letter from the disciplinary proceedings. The judge's letter was sent to the minister of the day that the National Prosecutor Office committed all prosecutors to inform him of all incidents where attorneys undermined a judge's status. Perhaps the judge who ran my case felt he was obliged to do so as well. This case brings us to two faults. Firstly, we have known before that there were some judges who sympathized with politicians. But for the first time, we saw that there are mutual contacts or also concern individual matters of our clients. In fact, we saw the judge declare that he was acting in accordance with the expectation of the authorities. Obviously, this is an unbelievable denial of the principles of the independence of the court and the separation of powers. Secondly, the executive power uses intimidation against attorneys. The initiation of disciplinary proceeding for taking litigation action by the lawyers is intended to have a chilling effect. It is supposed to remove from the courtroom the problem of defective judicial appointments that do not guarantee independence. The two problems mentioned above are extremely worrying from the point of view of maintaining the rule of law in Poland. Thank you for your attention.
Hello, my name is Anaïs Marin, and since November 2018, I have been holding the mandate of UN Special Rapporteur on the situation of human rights in Belarus. This mandate was established by the Human Rights Council of the UN in 2012. Regrettably, the human rights situation in Belarus has gone from bad to worse since then. This is particularly evident in the context of the judiciary. For decades, the rule of law in Belarus, or rather lack of it, has been a serious issue of concern for the UN system. The Belarusian judiciary is marred by procedures for the appointment, tenure, and removal of judges that undermine their independence. The due legal process is often violated by politically motivated procedural violations and disciplinary sentencing, with almost no respect for presumption of innocence and the right to a fair trial. One of the greatest challenges stems from the fact that the legal profession is under considerable systematic pressure and tightening control. Let me remind of a number of institutional features that specifically endanger lawyers in Belarus. The Belarusian legislative framework effectively limits the independence of lawyers whose activities are under excessive control of the Ministry of Justice via the Belarusian National Bar Association, an institution which has lost the features of an independent self-governing body able to defend the interests of its members. In order to exert their profession, lawyers must receive a license delivered by the Ministry of Justice, following an examination by a certification commission, which is itself controlled by the ministry. There is still no effective mechanism for lawyers to appeal the certification commission's decisions. In other words, are certified or disbarred not by their peers, but by the executive, which violates the fundamental rule of the separation of powers. Although licenses are issued for life, Belarusian lawyers have to undergo certification inspections every 5 years, while the authorities can request ex-prompt inspections at any time. It appears that they do so in a selective way, and most inspections are politically motivated. This aims at putting pressure on lawyers perceived as being critical of the government, either because of earlier statements they made in court or because of the type of clients they defend. Especially concerning is the fate of lawyers who protect human rights defenders or defendants in so-called political cases, such as opposition leaders, civic activists, peaceful protesters, independent journalists, bloggers, etc. The authorities reportedly use laws and procedures selectively to silence or intimidate lawyers who work on such sensitive cases, with the consequence that defendants, who are oftentimes victims of human rights violations themselves, are left without a proper defense. The fact that the state attacks lawyers to bar access to justice for those expressing dissent or criticism of the government and its policies leads lawyers to self-censorship and adds to people's distrust in judicial institutions. In addition to these structural deficiencies, which I highlighted in my 2020 report to the UN General Assembly, over the past 18 months, lawyers themselves have been regularly subjected to arrest, detention, and criminal prosecution in the context of the ongoing crackdown. According to the International Federation for Human Rights, at least 23 Belarusian lawyers have been disbarred in the year that followed the contested August 2020 election. In March 2021, 7 lawyers were requested to take an examination to recertify their qualification, a move justified by their alleged improper performance of their professional duties, I quote. Only 1 of them passed the examination, 3 had their license suspended for 6 months, and 3 more lawyers were disbarred altogether. The arbitrary disbarment of Belarusian lawyers has created a protection gap for their dependent relatives, notably children, when lawyers are prevented from earning a living to take care of their family. In addition to targeting lawyers individually, in 2021, the law on the bar and advocacy in Belarus was amended to restrict even more the rights and independence of lawyers, while increasing the Justice Ministry's control over the profession and bar associations. This contributes to the serious erosion of the commitments to international law and its institutions that we have observed in Belarus since 2020. Let me remind that the harassment, intimidation, and prosecution of lawyers for carrying out their professional duties goes against Principles 14 and 20 of the UN Basic Principles on the Role of Lawyers. It also restricts the right to freedom of opinion and their expression, and the right to counsel and equality before the courts, as guaranteed by the International Covenant on Civil and Political Rights, which Belarus has ratified. Yet in Belarus, the judiciary has become an integral part of the repressive arsenal used by the authorities to crack down on dissent. The overall institutional and legal setup not only limits the independence of lawyers, it literally endangers them professionally and often personally. I would like to use this opportunity to call upon the international community to do more to safeguard the ability of Belarusian lawyers to exercise their activities without interference, which is especially vital in the context of the crackdown on human rights and civic space currently underway in Belarus. Thank you.
Good afternoon. My name is Dimitrilajevsky. I am a lawyer from Minsk, Belarus. Until recently, I was a managing partner of the Attorney's Bureau and specialized in defense from criminal prosecution of business. Since June 2020, I had defended Viktor Babaryka, the most popular opposition politician in Belarus. And later, I also had defended his lawyer, Maxim Znak. Both of them did not commit crimes, but faced politically motivated prosecutions. As a part of their defense, I publicly criticized the illegal actions of the state authorities. In connection with this work, I faced various forms of pressure. That's why I know well what threatens the bar members. Wanting to silence lawyers, the Belarusian authorities oppose lawyers in several ways. The first way is directly through the Ministry of Justice. For example, as happened in relation to Alexander Pilchenko, whose license for advocacy was unlawfully terminated by the Ministry of Justice for an interview on what powers the state officials have to stop violence against peaceful protesters. The second way is through the criminal prosecution, as happened in relation to Maxim Znak, who was sentenced to 10 years in prison on fake accusations of calling against national security, creating an extremist community, and conspiring to seize state power. In addition, the authorities began to massively use such a method as taking a signature from a lawyer not to disclose information from the preliminary investigation. But with such a signature, a lawyer under threat of personal criminal liability is prohibited from disclosing an unlimited range of information. This makes it risky for a lawyer, even make public the effects of violations of the client's rights. In addition, during 2021, lawyers who defended political prisoners were persecuted in the state media. Publications were posted with insults and threats against lawyers. The third way is the most important Belarusian feature, that the government began to eliminate active defenders through the disciplinary procedures of the bar associations, which are completely subordinate to the Minister of Justice. How did it become possible? The final touch was in spring of 2021, when amendments were made to the law, according to which members of the councils of the bars must be approved by Minister of Justice. At the same time, the Minister of Justice has two powers in relation to the members of the councils of the bar. First, the Minister of Justice has the authority to make sudden attestation of any bar member at any time, and which is an exam in the legislation with the ability to ask an unlimited range of questions on any branch of law, regardless of specialization of the law. And the second is that the Ministry of Justice is also empowered to initiate disciplinary proceedings against bar members and remove them from their professional activities. As a result of the existence of these powers of Minister of Justice, the bodies of the bars are ready to initiate the deprivation of the status of any advocate whom the authority consider undesirable. That is, the bodies of the bar became the executor of state repressions against bar members. For example, Andrei Machalov was expelled from the bar for reporting to the media about police violence against his client. I was expelled from the bar for the fact that while defending Viktor Babarika, I asked the court to acquit my client, Viktor Babarika, and several other defendants due to absence of a crime. Such was my misdeed. And many bar members were affected by the same way. I will also note that the Belarusian Republican Bar Association is controlled by pro-government Senator Viktor Chaichets, who publicly threatened that lawyers would be guided by orders of state authorities. It was in spring of 2021, and since the end of 2021, the chairman of the Minsk City Bar Association on a weekly basis makes a report to the Minister of Justice. It's obvious that such bodies of the bars are dangerous for those lawyers who honestly and on principle fight for their clients. My advice to colleagues from other countries, in order to ensure the independence of the profession, you should not allow such legal regulation as we have. And you should not allow populists into the leadership of the Bar Association. At the same time, you have to teach young lawyers to be free. And if the authorities began to put pressure on any of the lawyers, then everyone must fight for him together. Otherwise, the authorities will understand that they can put pressure on everyone with impunity. Thank you very much for attention and good luck.
Hello, I'm Natalia Matzkiewicz, a human rights lawyer. I worked as a lawyer in the Minsk City Bar for 27 years, till in October 2021, I was disbarred. During the last 15 years, I specialized in providing legal aid to activists, human rights defenders, journalists, politicians, as well as defending them in court. However, my career ended after the trial of my defendant, Viktor Babaryka, and in the midst of the court hearings of my other client, Sergei Tikhanovsky, both of whom were main political opponents of Lukashenko in 2020 presidential election. I should say that Belarusian human rights lawyers routinely face repressions when doing such work, especially during periods of heightened social and political activity in the country. This is why, from the beginning of the 2020 electoral campaign, which sparked what was deemed to be the most serious crackdown to human rights in Belarus post-independence history, it was evident that lawyers would also risk persecution for their work. In 2020, lawyers initially faced an obvious violation of their professional rights, guarantees, and fundamental rights of their clients, and later were subjected to personal threats and harassment for their professional activities, which continued in 2021. Punitive measures were used against lawyers who represented protesters, opposition figures, and activists, or those who spoke out against violence. The government's action against lawyers over 2020-2021 have taken the form of criminal proceedings, administrative detention, and penalties and disciplinary proceedings, which in more than 40 cases have resulted in disbarment. Some journalists ask me, what is the point to persecuting lawyers when the law does not work and the decisions of the courts are predetermined? I think that the contrary to the popular belief that lawyers do not have influence over the final verdict, the voice of a lawyer can be heard in the courtroom and in public space. Ultimately, this is the voice of truth and law. That is the main reason why they want to deprive us of this voice, deprive our clients of support, deprive society of an alternative view which infuriates the regime. My voice was infuriating to them when I told the public about the torture of my clients, a blogger Nikolai Didok, in November 2020. My voice was infuriating to them in June 2021 when I proved gross violation of human rights and the political motive behind the criminal persecution of Viktor Babaryka during the court hearings on this case. Even in closed trials of Sergei Tikhanovsky, who was judged solely for his words and ideas, my voice was so infuriating to them that the Ministry of Justice suspended me in the middle of the trial and initiated disciplinary proceedings against me. As a result, I was disbarred and never came back to the court. I'm not alone in this situation. Many brilliant legal professionals were also disbarred and now deprived of their practice. Sadly, there is a little hope that the situation will change in near future. However, we do not feel defeated because recent events show that there are many lawyers in Belarus for whom their professional honor, adherence to law and clients are more important than their own well-being. This is why we keep going forward and developing this potential so that one day we can lay down a solid foundation of the future Belarusian legal profession. Thank you.
I'm Lyudmila Ulyashina, human rights lawyer, doctor, head of the Center of Constitutionalism and Human Rights, chair of the Senate of the European Humanity University, Belarusian University in Exile. Having extensive practical experience in Belarus as Belarusian lawyer in the past, I have studied and made my academic research in Germany and Norway, and have also developed my experience in international cooperation and by designing, leading capacity building programs and courses for practicing lawyers and law students. The Day of Endangered Lawyers is observed by numerous bar associations, individuals, and human rights organizations around the world. Thank you for the opportunity to talk about destiny lawyers in Belarus. My statement I devote to Belarusian students, scholars, and the brave practicing lawyers who sacrifice their wellness for values of justice, rule of law, and human rights. European Humanity University operates in Lithuania, a neighboring country to Belarus, who opened academic freedom for the EHU in 2004. Since that time, our university continues to be a forum for hundreds of Belarusian students, scholars, teachers, and lecturers, including those from lawyers' bar associations and civil society organizations. The EHU was established in Minsk in the early 90s, right after the independence of Belarus was declared. However, in 2004, this university was seized by presidential decree with explanation that the state should educate its elite, including law students, and only in the state universities. Lawyers indeed depend very much on the political and social environment where they study and practice the law. When we talk about lawyers working in non-democratic states, we shall understand the context and the genesis of the overall situation in the country region. Gustav Radbruch, German law scholar, reminds us in his article Gesetzliches Unrecht und Übergesetzliches Recht, or Statutory Injustice and Suprastatutory Law, that in the Nazi time, the postulate of the law in the law has disarmed lawyers in the face of government's regulations with a clearly criminal content. In Belarus 2020, the high state authorities went even further by declaring that currently the law is not the most important in the country, not up to laws, literally. Belarusian advocates call the current period of Belarusian history a legal default. When we take a look back to the time when Belarus declared its independence and the concept of judicial and legal reform was adopted by the Belarusian parliament, we all experienced kind of real uplifting, which was reflected in the concept. Lawyers have been called the most important institution for the state governed by the rule of law. Due to their role, lawyers always stay as mediators between the normative framework and the social reality. They translate messages from the state law to people and vice versa. But the social reality or the government have departed far away from the rule of law. The situation demands from lawyers to be able and free to express a critical stand. For Belarusian lawyers, a critical stand today leads to disbarment or even arrest. Nowadays, since August 2020, more than 40 honest professional lawyers were expelled from the Bar Association. Maxim Znak is sentenced to 10 years in prison. Lawyers of civil society organizations, including our guest lecturers, Leonid Sudalenko, Valentin Stefanovich, great human rights lawyers are detained for their professional determination for human rights. For scholars and law students, their critical stand cost their job and possibility to continue their study in Belarus. We have no exact numbers, no stories about all students from Belarus state universities, scholars, and teachers who lost their seats and jobs. We welcomed more than 40 students who have been enrolled into European Humanities University law program. Several brilliant scholars and practitioners have been affiliated now with the university after being expelled from the bar and state Belarusian universities. Regrettably, several EHU students, law students, have been detained in Belarus. Dozens of our students went through administrative arrests for their participation in peaceful protests and or for other ways of expressing their position while being in the country. It is not usual today under current situation to ask or reveal personal stories. However, let me share with you a story about a student of the law faculty of the Belarusian State University, Ekaterina Vinnikova. In her speech at the graduation ceremony, she has appreciated her teachers. She recalled them, and among them also lawyer Maxim Znak and other dismissed teachers. She addressed from the stage to her colleagues and wished to love and defend the right with the honor and dignity of a real lawyer, regardless of the difficulties that are and will be. Next day, after the graduation ceremony, Ekaterina was detained. Her hostel room was searched. On July 2nd, the Leninsky District Court of Minsk sentenced Ekaterina with 50 days of administrative arrest, quote, illegal picketing by expressing public and political views and speaking on the stage against the persecution of lawyers. Amnesty International has published a press release dedicated to Ekaterina Vinnikova, demanding the immediate release of her. Those calls were not heard by government. To conclude, what lawyers of other countries may do. Value the great potential of the lawyers community, including academical units and university. Express support, stay by Belarusian lawyers, and see them not just as victims, but colleagues who are protagonists for the rule of law and human rights in future Belarus. Thank you very much.
Good afternoon, dear colleagues. My name is Mikhail Kiryuk. I worked as a lawyer in Belarus from 2015 to 2020, specializing in commercial and corporate law. In August 2020, after the mass protests, dozens of people began to come to my office to be significantly beaten, traumatized, and subjected to serious violence. As a result, I began to defend political prisoners. I told the media that political prisoners, including my clients, were tortured. In October 2020, I received a threat of arrest and had to leave the country with my family. In the winter of 2021, the Department of Justice revoked my license. The official wording was for criticizing the Belarusian authorities. The present Ministry of Justice considers any criticism of Belarusian authorities as a violation of legal ethics and sufficient grounds for revelation of the law license. The new Minister of Justice is a former police officer without even legal education. However, there are those who have suffered more than me. Maxim Znak has been in jail for more than 2 years. Maxim is one of the top lawyers in Belarus, a member of the legal 500 IFLR 1000 Who's Who Legal. He defended and represented the election candidates Viktor Babaryka and Svetlana Tikhanovskaya. Maxim was convinced after several articles of the criminal code, including conspiracy to seize power by unconstitutional means. His sentence is 10 years of imprisonment. Maxim is a member of the Presidium of the Coordination Council, which called for a change of power in Belarus through elections. It's indicative that the Belarusian court considers the calls for free and fair elections in Belarus as an attempt to seize power through unconstitutional means. That shows us that Lukashenko believes that the only legal way to change the government of Belarus is to change it to the one Lukashenko wants. Lilia Vlasova, Ilyas Aley, Lyudmila Kazak, all these lawyers were jailed for defending their clients. For only their will not to live in a country where the law has been replaced by the mere wish of armed men. More than 30 lawyers in Belarus have been deprived of their licenses and the possibility of practicing law in Belarus. Some of them, like me, were threatened with arrest and forced to leave their homes, law firms, practice, and clients and flee from the country. After the expulsion of the active part of the lawyers, Lukashenko's Minister of Justice, together with the heads of the bar associations, carried out a reform of the legal profession in Belarus. Lukashenko's parliament amended the law on the legal profession in Belarus and banned private attorneys. The only legal license that is now issued to private law firms gives the right to consult only corporations, not persons. It does not give the right to defend interests in court. Now there are no private attorney firms in Belarus. Anyone who wants to be an attorney at law and defend clients in court is obliged to get a job in a state consultation office. Lawyers now are often deprived of the right to go to jail to see their clients, so they would not be able to see signs of violence carried out towards their clients. When a lawyer sees signs of violence and starts to speak out about it, he gets threats of arrest and disbarment. Many lawyers refuse to defend political prisoners for their own safety. Therefore, the role of lawyers today is severely limited. Unfortunately, the lawyer's role is often reduced to that of a very expensive letter carrier. The lawyer can pass an information to relatives and advise about prison conditions. But there are those who, even under such difficult conditions, continue to help political prisoners. How can we help them? Expressing solidarity is right and sufficient for the Belarusians, but not enough. However, as long as Lukashenko remains in power, there is no chance of any improvement for the lawyers or the innocent citizens of Belarus who are in prison. As hard as it sounds, the only effective method to help the Belarusians is to change this power. Lawyers can do a lot here. They can at least not help Lukashenko campaigns to circumvent sanctions. They can prevent Lukashenko's campaigns from circumvention sanctions. They can help the Belarusian democratic forces in exile. Thank you for your attention.
Hello, I'm Lyudmila Kazak, ex-advocate from Belarus. According to official data, almost 2,000 advocates operate in Belarus. After the falsified results of the presidential elections in August 2020, Belarusian society faced an unprecedented level of repressions against its own citizens. It resulted in more than 35,000 detainees, more than 4,600 criminal cases against protesters, 974 political prisoners. Each person has been provided with qualified legal assistance. As a result, the advocates themselves became a subject of repressions. From October 2020 to the present, 43 advocates who worked on politically motivated cases have been deprived of the right to a profession. In all cases, it was done on an arbitrary basis, inconsistent with the principle of the independence of advocates, incompatible with the guarantees of a fair trial. The Ministry of Justice actively uses well-established mechanisms to punish advocates. First, these are regular and ad hoc appraisals during which an advocate is declared to be insufficiently qualified to continue legal work. In second place is the initiation of disciplinary proceedings and, as a result, the expulsion from local chambers. The third one is declaring the advocate's actions as discrediting the bar. Chambers, local body of the bar, take active part in the repression process. Although their main task under the law is to protect advocates' interests. In practice, chambers eagerly followed the orders of the Ministry of Justice in relation to specific colleagues, expelling them from chambers without any legal grounds. In parallel with the personnel cleansing in the bar, there have been some amendments made in November 2021, according to which the total state control over advocates is established, starting with the fact that only applicants approved by the Ministry of Justice can be candidates for trainee advocates. Thus, the de facto and de jure, the Belarusian advocates are currently deprived of independence, which diminished the advocates' profession. Through the repression of advocates, the state pursues another goal: to put pressure on the members of opposition and to deprive their rights completely. Clients are facing problems with accessing legal aid. They are deprived of basic rights. The case of Viktor Babaryka demonstrates that because his advocates had their license withdrawn. Belarusian advocates today have no means to protect their interests because the law doesn't work in Belarus. Close attention of the European legal community to the process relation to the Belarusian bar is very important because it doesn't allow to hush up the violation committed by the state against advocates and their clients. Note that Belarusian advocates whose licenses were withdrawn need help and support from their European colleagues.